All right, I think we're gonna go ahead and get started. Thank you for allowing me to come present this award. My name is Ben Fernandez. I'm an intellectual property partner at WilmerHale in Denver. Each year we've been accepting submissions of papers written about a topic involving law and technology. This year's papers were read and judged by a panel of attorneys at WilmerHale. Why do we sponsor this contest? We sponsor this in order to promote and encourage among students the continued pursuit of the research, the planning, the organization, the writing, the editing of scholarly papers in this field. The winner receives a check for $1,000 and an opportunity for publication in a future issue of the Colorado Technology Law Journal. This year marks the 19th year of the contest and the 18th year of which I've had a privilege to be involved in the judging. WilmerHale is pleased to sponsor this competition. Once again, we thoroughly enjoyed reading all the submissions, and it was a challenge to pick a single winner, but as all judges must do, we picked one. And so at this time, I am pleased to announce that the winner of this year's WilmerHale writing competition is Richard Koch. Richard, if you'd like to come forward, please. So Richard wrote a paper entitled, "What Are You Looking At? Emerging Privacy Concerns with Eye Tracking in Virtual Reality." So we commend Richard for the research and the thought that went into this paper. Please join me in congratulating Richard once again.
To our sort of penultimate session here in this, the title of this panel, for which I have only myself to blame, is Making Sense of U.S. Platform Policy in Congress and the Supreme Court. And we have the special misfortune of trying to do that and returning to the U.S. after the remarkably organized, framework-oriented adult conversation that just happened about the European Union. I regret, I've taken my tie off. We have got to come back to the United States and make some sense of this. Fortunately, I have a wonderful crew of folks here to do that with me. Going from my left, we have Corynne McSherry, who's the legal director of the Electronic Frontier Foundation, Chris Lewis, who is the president and CEO of Public Knowledge, Jennifer Huddleston, who is now a research fellow at the Cato Institute, and finally Derigan Silver, who is the associate professor and chair of the, or associate professor, the chair of the Department of Media, Film, and Journalism Studies down at our neighbors at the University of Denver. So I am going to turn it over to Chris to have the especially unenviable task of starting us off with the landscape of what we're actually doing here in the United States. And as Chris gathers his thoughts a moment, I'll say, after we try and look at some of the legislative proposals, we're then going to shift to the conversations about Section 230 and the First Amendment that were teed up in previous panels. But Chris, try and make some sense for us of what is going on in the United States. Good luck.
Okay. Thanks, Blake.
You're welcome.
I'm buttoning a button, not just my tie. We have a lot of work to do, is the short answer. When I think about the landscape of tech policy in the U.S., we have a lot of work to do because we have a lot of fights that weren't really resolved, going back a decade or so. When you're thinking of things that maybe haven't been talked about a lot in this first day, like the digital divide, or protecting an open internet, or balanced copyright and privacy protections. And then pile on top of that the stuff that we've heard a lot about today. The things that Europe is ahead of us on. And much of that work feels often like it's a repeat of some of the same values, some of the same dynamics, slightly tweaked or flipped on its head for the new innovations that we've seen over the last decade. So we're still talking about privacy, even though We were talking about privacy in broadband before, but now we're talking about it across the entire internet. We're still talking about content moderation, as we have talked about with all media in the past. We're still talking about gatekeeperism, like we were in net neutrality, but it looks different with digital platforms, and how it looks different is very important to how you regulate it. And of course, we're talking about free expression, and you said we'll get to 2:30 and all of that fun. So we have a lot of work to do, and I think a lot of us are worried because, I think it was Gerard on the last panel talked about the quality of the debate in this room. We do not have the same quality of legislating going on in Washington. And that's what we need to deal with these complex issues. We have a polarized environment. We have, for my money, a very deregulatory environment. And yet we hear calls from folks who are both very regulatory and deregulatory for accountability, and that just doesn't square. We've got to wrestle with that. And to do that, I think it will take higher quality legislating and policymaking, and that looks like, wrestling with expertise and data and facts. I think that's true for policymakers and those of us who visit them and advocate to them. I think it's true of the press, who will cover a bill when it comes up for a vote, but maybe not when it's getting marked up, and the details are very important. And we need ongoing oversight and authority to deal with the technology as it innovates faster than Congress can keep up with it. And lastly, I think we need a will and determination to see these fights through on behalf of what is right for the public, not just for our one constituency that we represent. And we were just talking, Corynne and I were just talking about if you're a public interest advocate, we think you have to be an optimist by nature. That was not very optimistic. Here's where I'm optimistic. There's good work, some good work has been done. If you don't feel optimistic about the hard work that's been done to find compromise on privacy in the US Congress over the last 4 years, then I don't think you're paying attention. If you don't feel optimistic about dealing with gatekeeperism in the United States after watching the House Antitrust Subcommittee go through an 18-month study, which then led to legislation, like Congress used to do, lots of hearings and reports and facts, agree with their outcomes, with their like assessments or don't. But that's good legislating. We need to see more of that on these tougher challenges that haven't been tackled, especially around free speech.
So what I'm hearing is Congress managing to do some bipartisanship is sort of the red Corvette of the internet's midlife crisis. Hopefully we can, that's how we're gonna sort of move forward. So Chris, I wanna take this historical frame that you started with and open up to the rest of the panel just for their thoughts. And I think everyone on the panel is a veteran of the battles that you have talked about, or is deep on the history of them. I want to open up the panel. Where do we sit now? Do you all share Chris's view that we have litigated a bunch of this already and just sort of failed to solve all of these old problems and are now seeing Europe tackle them? Or please situate us in your view of the kind of history, and I'll start with you, Corynne.
So I think that where we are right now with respect to legislation in particular is that to the extent that there's movement in Washington, it's because there's movement in the states. I think that, I mean, I'm not saying all of it is that, but I think that, and I think other panelists have mentioned this a little bit, but I think it's important, for good or ill, the states are taking on a lot of the tasks that we might once have looked to Congress for. Again, for good or ill. So, we, after fighting for net neutrality for decades, it was upended overnight, seemingly, at least it felt like that. And so California's got a net neutrality law, and effectively that ends up influencing lots of other states. After trying to get good federal privacy legislation for decades, California passed its own. Now it's not perfect, but the fact that it got passed has now spurred the conversation in DC, because everyone realizes, like, I don't really want a patchwork of different potentially rival privacy obligations. So I think this is going to continue to be true. We're going to continue to see states sort of stepping in to fill a perceived gap. And I don't think that's always going to be great. I don't think that states are necessarily always the best ones to make these kinds of decisions. And I think with respect to online speech in particular, we'll probably get to this a little later, we've seen some terrible, very terrible, and directly contradictory state laws passing. So, you know, this isn't great, but it is, I think, a reality. And I think one of the things that I think about as an advocate, and I think many advocates should be thinking about, is, so how do we engage states, and how do we engage in this dynamic process in a way that's like reasonable and practical when we aren't located in every state and we don't necessarily have the ability to influence legislatures in every state? And there are powerful entities that do.
So to kind of build on what Corynne was saying, I think that we certainly are seeing a lot of action at a state level. The other example I think of is what we've seen in privacy. And I think that is part of why, as we start to see the privacy patchwork, particularly this year with effective dates coming into play in more states, become less theoretical and more a reality, that is why you are seeing a push on both sides of the aisle for potential federal privacy framework. Now, we may all disagree on what that framework should look like and on some very important issues around things like private rights of action, but you are seeing the discourse grow very early in this Congress. And so I think that is probably the thing I'm most optimistic about, that Congress could create both a privacy framework that responds to a lot of the concerns that consumers have, to concerns that businesses and innovators have, as well as to something that maintains a approach that allows innovation to continue to flourish. When it comes to what we're seeing happening in the speech debate, it's really interesting because we're seeing calls to say change laws like Section 230 from both the left and the right, but we're seeing them often for diametrically opposed reasons. So on the left, there's often expressed a concern about there's too much of certain kinds of speech online, too much hate speech, too much violent content, things of that nature. On the right, there's often a concern expressed that they feel that conservative voices are being silenced, or that too much content is being taken down, or that the wrong types of content are being taken down. As a result, I think we haven't really seen a convergence on an idea to lead to Section 230 reform more broadly, and I think that's actually a good thing. I think Section 230 in and of itself has really supported innovation online, and so as we look at what the states are doing there and how that could impact the patchwork of potential speech, I think that's important to consider as well. The other thing I would kind of like to respectfully disagree with Chris on is when it comes to the European approach and the idea of Europe as a leader that the US should perhaps be looking to follow in terms of regulation. Or I'm concerned that the European precautionary approach is becoming more considered in a lot of the US policies we're seeing in Congress, and that we're not considering fully the consequences that some of those policies, such as the competition bills that were mentioned, could have to consumers, could have to innovators, beyond just the idea of a more precautionary regulation, and looking at how many of these proposals would impact much more than just what we think of as tech companies, but a wider legal regime and a wider economic regime as a whole.
Derigan.
So much. I'm a little bit of a old wine, new bottle kind of guy. So I teach copyright law, First Amendment law, and privacy law. Three areas that frequently just like clash with each other and make no sense when you're trying to explain how copyright law and the First Amendment coexist in any coherent system whatsoever, because they can't. And so, but what I always tell my students is there's, in those three areas of law particularly, there's this inherent tension between technology and the law. So for example, in the 1970s, we had to have day-long, multiple-day hearings about this amazing new technology that we weren't sure how the law should handle it, and what should we do about it. And I always ask my students, I'm like, what technology am I talking about? VCR, no. The internet, no. Photocopiers, right? Like, we did not know how to handle photocopiers in libraries. You see the same thing with privacy law. I mean, privacy law is just over 100 years old. Depending on which scholar you talk to, a lot of it was spurred by the development of the instant camera, the Polaroid camera. So we have this technology that's pushing the law. In terms of content moderation, which is what I spend a lot of time talking about, every time we've had a technology that has democratized communication, we've had this huge panic over the results. So if you look at the printing press, oh my gosh, the commoners can read, what are we gonna do? And then you look at the penny press in the 1800s, when we moved from a partisan press model to a model that was driven by advertising dollars. So suddenly we needed a wider audience. So we're like, objectivity, that's a cool thing. We're like, oh no, now the masses are gonna read the newspapers. What are we gonna do? Radio, television, internet. And so this kind of inherent conflict between technology and the law has been around for a really long time. And we've yet to sort of figure out how to handle it. And we were just in this really wonderful, super nerdy conversation about the benefits of common law versus statutory law when it came to technology law, which I really enjoyed, but I don't know if you guys would, so we won't go into it here. So I'm a little bit, these are things we've grappled with before. In terms of our comments about Europe and regulation, whenever I'm teaching my students, they're generally very in favor of regulation that benefits what they see as right. And then they're against regulation that they see as wrong. And we frequently like regulation when we think that there's a benevolent force in power and we think that there's some greater good to happen. And so if you talk to my students, removing hate speech from the internet is their biggest priority. And they say the government should have the right to regulate the internet. I'm like, cool, like Florida, like Texas? And they're like, no, not like that. That's bad regulation. I want good regulation. And so I would say regulation is only as good as the people who are enforcing it.
Chris, a quick rejoinder.
I don't think regulation can be good also if it balances values. And I believe in a thing called the public interest and the public good. Determining that is hard because we have a diverse society who balance different values, take your pick, free expression, content moderation, fighting hate speech, fighting misinformation. Different people answer that question differently. What we've been able to do at times with other media is we've been able to have regulatory bodies that are nimble and that can make mistakes but then recalibrate. That can be a good thing. We've been able to balance values by talking about them when we're going after a specific harm, but knowing that if you go after that harm with a remedy that will hurt another value, that we figure out ways to either address that or acknowledge the consequence of that choice. So, you could have, you can't in the US, but if you had the government say that all hate speech is banned online, which is not legal to do right now, that's one approach. You could also find other ways to limit hate speech online. You could look at how competition policy contributes to limiting hate speech on dominant digital platforms where most people would see it. That's how it worked with the printing press. Growing up in Northern Virginia, I knew where the skinheads were because when you went to that neighborhood and parked in, there they would put flyers on your windshield. I didn't have to like it, but it was their right to do so. So there are ways to balance it, especially when you're trying to get at one harm or the other.
So let's pick up on this note of balance, and I want to shift us over to thinking about Section 230. One of the sort of unique things about the U.S. approach to all these issues that we're talking about is for the last 25 plus years, we have operated from a starting point of Section 230 that says that when it comes to these issues, we're going to leave the decisions in the hands of the platforms to decide what sort of speech is going to flow. So, Corynne, we heard earlier that no one understands what Section 230 is, the most misunderstood issue among, and perhaps intentionally so, among politicians and the public. I wonder if you could give us a sense of what's the non-folk law, like real version of Section 230, and then we can get into how the Supreme Court might be deciding to mess with it.
Okay, yes. So it's also, I think it's important, especially for our Supreme Court conversation, that we're talking about Section 230 and the First Amendment. And there are ways in which they overlap and there's ways in which they don't, but both of those are in play, or both of those laws are in play. So I would not normally ever do this, but I'm actually going to read sort of the key language from the statute. I promise I never do this, but you'll see why. No provider of an interactive shall be treated as the publisher or speaker of any information provided by another information content provider. You know why I can read it? Because it's freaking short. It's really short and it's really powerful. There's another part of Section 230 though that's also important, and I'm not going to read it because it's not as short. But so one of them, C1 protects platforms and also many kinds of services, which we should talk about, from liability. Basically for content generated by their users, for hosting content or for otherwise providing a service, right? Probably everyone in this room knows this. Often forgotten in the discussion is it also protects them from liability if they decide to take content down. So that provides them some freedom to do the content moderation that everyone and their mother seems to want them to do in exactly opposite ways. But that's the basic structure of the statute. And that plus the First Amendment protects content moderation sort of generally. It protects the ability to engage in content moderation without being held liable for what your users do. So what we all know is if companies were held liable for all the speech that they host, well, first of all, many of them wouldn't exist. And some people would like that. Perhaps we'd like a world without Twitter, but we wouldn't have it. If it wasn't for Section 230 and the First Amendment, because the First Amendment provides additional protection for curation decisions. And this dates well before the internet. Derigan can talk more about that, but it's a long-standing idea that publishers should be protected and platforms should be, of all kinds, should have the right, the First Amendment protected rights to make editorial decisions about what speech they're going to host and what they're not going to host. So those two things protect those two things. Protect the full spectrum, or most of it, for content moderation at the platform level, but also for all kinds of services like email. Email relies on Section 232. The last thing to know, just to set up, and then I can talk about the Supreme Court if you want, of both those cases. There are exceptions in Section 230. There's exceptions for intellectual property, federal criminal laws, and now, thanks to an unconstitutional law called FOSTA that we're going to get overturned really soon. But for now, speech that violates.
I thought we were trying to make new laws today. The whole conversation.
Sorry.
Okay.
Sorry. Okay, but if you talk about sex, or if you have a speech that talks about sex, you might be in trouble, which led to a consequence that we should talk about, which is that when platforms don't have that protection, when they're at risk for liability, they do what you might expect they would do, and they over-censor. They take down any content where they might be risk because they don't want to pay lawyers to litigate it.
So before we move on to the Supreme Court's impending treatment of this, I wonder if I could get just a lightning round reactions to Corynne's description of Section 230. This is pretty important for platforms. It's obviously shaped how platforms have grown up in the United States over the last 25 years. How do folks feel about that? Is that something we should be proud of relative to the European tradition, which doesn't have Section 230? What's the valence of Section 230 over the last quarter century?
When we're talking about Section 230, you often hear it brought up in the context of quote unquote big tech, of the largest platforms out there, the Googles, the Facebooks, the Twitters, which if you actually look at numbers is surprisingly small compared to many of these other platforms. But the reality is that Section 230 and particularly Section 230 liability protection benefits users by providing them more opportunities to speak, and also benefits innovation by creating this kind of level playing field, in my opinion, for startups that want to carry user-generated content. Because now they're as equally protected if something goes awry and somebody uses your new messaging service, your new review site, your new alternative encyclopedia that's completely created from user-generated content for something you never imagined. Your second hire doesn't necessarily have to be a lawyer. Now, that may be against the self-interest of some of us in the room who are lawyers, but the reality is that it's the benefit to the users to have those opportunities for speech, and it's the benefit to all of us to have more choices in this case at times to find that right type of information that we're looking for. We're not just talking about social media platforms in this case. When we're thinking about what we're seeing right now in the dynamics in this industry, Section 230 may come up in the context of those large platforms, but this is also critical when we're talking about the emergence of new platforms. So when we're seeing things like people who are looking to alternatives to Twitter, but maybe they aren't happy with how Musk is engaging in content moderation right now, and so they're looking for things like Mastodon. We also see this with some of the new right-leaning sites. For example, when Trump got kicked off of social media and he created his own social media platform, in part because you have a culture that allows user-generated content to flourish, you're really seeing a ecosystem for a variety of online opportunities for speech.
So Chris, I want to come to you, and I want to link to Senator Bennett's remarks this morning.
Yes.
Senator Bennett talked about, I think, what Jennifer just described as something a little more sinister in his words. He used the words algorithmic poison, talked about authoritarians platform, it makes these platforms the authoritarians' platforms of choice, something along those lines. And that 230 is perhaps kind of at the heart of that. Your thoughts?
Thanks. I have to admit, I didn't catch his speech. So those are spot quotes. I don't want to necessarily attribute my thoughts to the senator, but I will say that what I know the senator believes in is having accountability and regulation of these platforms. I would agree with that. I don't think that has to conflict with preserving Section 230, which I think is on the whole a good piece of policy. Authoritarianism, I think, putting the power to moderate in the hands of the platform was the right choice. In the United States, we have a tradition, we don't want it in the hands of the government. If we put it in the hands of the government, it's very limited. I would encourage that for the internet. And with a piece of media like the internet that is so powerful and for democratic speech, but puts accountability, just diffuses accountability across the entire user base, you don't have a lot of other places to turn. I think it requires then us to look at certainly competition policy to make sure that those who don't like the choices that they get in content moderation can go elsewhere. We're certainly seeing that on the right. We see market pressure from the left to try to address the lack of content moderation from their perspective. I don't think it's been very effective because we don't have great competition, especially on social media. And so doing more to promote competition, I think, could go a long way to supporting the free expression goals that we traditionally had in this country without getting rid of 230.
Okay, against the backdrop of views on 230, Derigan, I wonder if I could turn to you to talk about an entity that rarely makes an appearance at this conference, but I think we got to go there, which is the Supreme Court. What is the Supreme Court poised to do with Section 230, and what could the consequences be?
Who knows what they're posed to do? Again, you have to remember that sometimes the First Amendment and Section 230 overlap. Section 230 was really, if Tim is still here, Tim Wu has a really great article from 2018 called "Does the First Amendment Matter?" And in the article, the thesis is that you have to understand the First Amendment, not as an originalist, but really understand what it was designed to do and what was the reality that was going on at the time. And I think you have to do the same thing with Section 230. You have to take yourself back to the late 90s. You have to sort of think like, what was the goal of this legislation? What were they trying to do? For a couple of common law cases that were coming up, there was a debate about something called the republication rule. And one important thing to remember is that Section 230 protects internet service providers, not because they're publishers, but because they are not considered publishers. Under the common law, there's something called a republication rule. It basically means that anybody who spreads a lie is as liable for that lie as the person who originated the lie, or the teller of tales is as guilty as the originator of tales. In the late 90s, we had two competing internet service providers that my students have never even heard of before, one of them being Prodigy. And under the common law, if you were somebody who edited your material, if you were a newspaper, you were responsible for the content that was in that newspaper, regardless of who generated that quote. So if I am a reporter and I'm covering Senator Bennett and he defames somebody, and I write in my newspaper his word-for-word quote that he defamed somebody, Senator Bennett can be sued, and I can be sued. If I get a letter to the editor and I publish the letter to the editor because I'm making that decision to publish it, I am now a republisher of the letter to the editor. The person who wrote the letter to the editor can be sued. I can be sued. There's these two internet service providers who had differing business models. One was sort of the laissez-faire, publish whatever you want to publish. The other one marketed itself as the family-friendly internet service provider. And they said, we edit the content, we make sure that everything's going to be safe. The court sort of took that different ways and said, well, you are a publisher, you are not a publisher. You are liable for defamatory contents. You are not liable for defamatory content. So when there was this discussion about having internet service providers help to moderate content, internet service providers were like, no, thank you. Like we do that and we're now liable for everything that we publish, every email that we send, everything. Under the common law, a telephone line, a bookstore, a newspaper, or a newsstand, these are considered common carriers. That requiring a telephone company to monitor every single phone call that is ever made on a telephone line would drive them out of business. Asking a bookstore to do the same thing would drive that bookstore out of business. So you had to decide, what are these internet service providers? Since then, courts have really interpreted that term, internet content service provider, very broadly. And it has been applied to a wide range of websites for just about every tort. So it's gone, republication rule has its basis in defamation law. It's now gone to privacy law. It's gone to defamation law. It's gone to even other areas of content. And this concept of who is an internet service provider has been interpreted fairly broadly. One of the only big losses that I'm aware of comes from a case involving roommates.com, where they had a drop-down menu that forced you to choose the preferred race of your roommate. And because they were forcing you to make this choice, the courts basically said, okay, you are now a publisher. You are now forcing people to break the law. You are liable under Section 230 for this drop-down menu. In most other cases, there was one other, I think it made it to the circuit court level. Maybe it didn't quite make it to the circuit court level. I think it got overturned en banc involving the dirty.com, which was held liable for about $500,000 in damages from a former cheerleader of the Cincinnati Bengals. That was actually, Section 230 is ending. The courts have had it. They're tired of this. Like, the dirty is an example of a bad Samaritan, and Section 230 is going to end. It ended up getting overturned on appeal. But now there is a case going up before the Supreme Court, Gonzalez versus Google, where the argument is, Google is making the argument that, and help me out if I'm getting this wrong, guys, the algorithm that Google uses to select ranked choices should not be protected under Section 230 of the Communication Decency Act. And there is this debate about how much of the internet and how much of this technology is actually protected by the First Amendment. Is code speech? Is code content? Is selecting the ranked order of websites protected by Section 230, or is it not protected by Section 230? So we all have to remember that in the United States, statutes are the creation of the legislative branch, but statutes, just like the Constitution, are subject to legislative interpretation. And you have at least one justice who has openly said that he believes Section 230 has been wrongly interpreted by the lower courts. That's Justice Thomas. You have another justice, Justice Alito, who basically doesn't trust anything you have to plug into the wall. If you plug it in, he wants to take a second look at it. And so there's this real question that we have this really large body of case law in the lower courts. And for now, it looks like the Supreme Court will decide some of these questions about how broad is Section 230. Did I get Gonzalez versus Google right? Did I miss anything?
Except that Google is arguing that the algorithm is
protected by Section 230. Did I say it's not? They're saying
yeah.
they are not liable under Section 230 for the algorithm. So for example, if Google returns searches that you don't agree with or you don't like or whatever the case may be, could you sue Google for the search results, or are the search results protected by Section 230? And there's a really famous law article that came out a few years ago, which actually turned out was commissioned by Google, arguing that this particular computer code is actually speech. So there could be both a Section 230 argument and a First Amendment argument involving Google code.
I want to turn things over to Corynne and then back down to Jim.
Yeah, so just to fill in a little bit more context for Gonzalez and also for the earlier case, Tomney versus Twitter. Both of these cases are going to be heard in a couple of weeks, so stay tuned for that late breaking news. I think it's important to know that in both of these cases, a number of us are concerned because the facts of the cases are terrible. Both of them, so I'll just back up and do Tomney real quick, just because we haven't talked about that yet, but they're sort of a pair of cases that the court essentially decided to take both, and who knows why, but probably not great. Anyway, so Tomney arises out of, there's an ISIS attack at a club in Istanbul, and family members later sue Twitter and other platforms under the Anti-Terrorism Act, which allows a U.S. person to sue an entity that knowingly provided substantial assistance to an act of terrorism. So that question there is actually not strictly speaking a 230 question. It's much more of a First Amendment question, which is how do we interpret the ATA? Could Twitter have been sort of aiding and abetting by not being aggressive enough in terms of trying to take down terrorist content? And related is general knowledge that ISIS people use your service to try to get the word out and radicalize and so on. Is that generalized knowledge enough to be knowingly providing substantial assistance? And there's one analysis that says you can't interpret the statute that way, consistent with the First Amendment. That is not, but that is where that is sort of squarely presented. But it relates to the second one because both of them have to do with how are we going to think about the liability of platforms for the content that they host. So that's why people sort of put them together in obvious ways. A concern I have, by the way, is that whatever ruling we get out of here is not going to be confined just to platforms. It's going to be a ruling that's going to affect services up and down the stack. Anybody who relies on 230 is going to be affected by this. And then the other thing I would say that I think it is important to think about. So Google is saying, look, our recommendation algorithms, that's the same as curation. That's the same as editorial decisions that are protected by the First Amendment as well as 230. But there too, the facts are terrible. So we've got radical ISIS videos being shown and recommended by the algorithm, and the argument that was used to radicalize people and ended up, supporting another ISIS attack. So those are sort of, it's just, these are the worst facts possible, right? Because it's terrible. What happened to the women, to the people who are suing, they all lost family members directly. And they are trying to say, look, the social media platforms have a responsibility here. They are part of, they are part of the algorithmic poison, and they shouldn't get off the hook. And I think that, there's justices on the court that are going to be very sympathetic to that. On the other hand, as a matter of law, it's very difficult to figure out how they are going to rule the way their hearts might want them to without rewriting Section 230 probably and interpreting the First Amendment in a way that may have really far-reaching consequences.
Okay, so I want to get back to the ramifications of this as our sort of closing question. But before we do that, I want to make sure we also get the First Amendment cases that the Supreme Court is going to take or are probably going to take on the table. So Jen, I wonder if I can come over to you to tell us what's going on at the Texas and Florida legislatures. Well, I mean, not like generally, but, specific to these laws.
Could you
And then
Yeah.
how are the courts going to deal with that, and how's that going to head up to the Supreme Court?
So what we have seen are two state laws seeking to regulate social media speech. And these are two laws out of Texas and Florida. They vary a little bit from each other, but in both cases, they're concerned with what they consider political speech and with the removal of political speech largely for conservative candidates or conservative points of view. What we ended up seeing is that there was a circuit split. The 11th Circuit, which handled the Florida case, found that the Florida law was unconstitutional on First Amendment grounds. The Fifth Circuit upheld most of the Texas law. There are preliminary injunctions in place in both of these laws. Because you have a circuit split, it does look likely that the Supreme Court will take it. However, when it was reviewed in conference recently, they asked for the opinion of the Solicitor General. So it looks like if these cases are heard, you will not see them on the docket most likely until next Supreme Court term. But with that in mind, while you often hear, because these cases involve large social media platforms, these brought up in the context of Section 230, at their heart, both of these cases really are First Amendment cases. And in fact, the questions posed to the court are First Amendment questions, not Section 230 questions, which distinguishes them from the two cases we were talking about involving the Gonzalez case and the Tamna case, where Section 230 is directly in the question presented to the court. These really are questions about First Amendment speech and how that interacts with the broader kind of questions of the state getting involved in telling platforms whether or not they have to carry certain types of speech or certain speakers.
The one thing I would add is that both of these laws under existing precedent are blatantly unconstitutional. Like blatantly. This is something that you learn, right? There's a case called Miami Herald versus Tornillo, which basically says you can't do this. And I think, so there's in the political science literature, and this would be a whole other interesting debate if we're going to talk about Congress and the courts, in the political science literature, there is a theory that frequently legislatures will work with the courts as a backstop. So basically I can pass laws that I don't think are really good laws, but they're politically popular. And I know that the court will act as a backstop, right? Like when I pass this law, there is no way that the Texas state legislature, that people didn't come up and be like, this is unconstitutional, right? They passed it anyway. Maybe or not, thinking, well, this is not going to go anywhere, but boy, it looks really good to our constituents. I mean, in my opinion, anything that comes out of the state of Florida or anything that comes out of the state of Texas has as much to do with the 2024 presidential election as it has with being a good idea. But the Fifth Circuit really was like, no, we're gonna let this one stand. We think this is actually a pretty good idea. And the 11th Circuit was like, have you read case law? Like this is just blatantly unconstitutional. And so in addition to the Solicitor General asking for, or in addition to the court asking the Solicitor General to brief the case, in the denial of the stay in the Fifth Circuit case, was it the Fifth Circuit or the 11th Circuit? Alito wrote a dissenting opinion where he kind of starts it off being like, I'm not saying how I'm going to decide this case, but I don't really think the First Amendment applies to large social media platforms. I'm not saying it does, I'm not saying it doesn't, but it is a question the court should answer, whether the First Amendment applies to these entities.
Okay, so I want to take our last 5 minutes here with this framing, and it's a pretty stark framing because I think we heard during the journalist panel pretty much a consensus. Not much is going to change in Congress in the next few years. We're going to be reprinting the heading about Congress not doing that much. But we have some pretty significant changes to the backdrop against which Congress is going to legislate. Potentially Section 230's immunity for editorial decisions that platforms are making either to filter or to leave up content might not be protected in the same way. Potentially the understanding of how the First Amendment constrains states from legislating when it comes to the carriage and filtering decisions of platforms could be changed pretty radically. So let's say that we are in a world, and this is the question I want to close with, and I want to turn to everyone in turn. If we're in that world in a year where the Supreme Court swings for the fences on 230 and the First Amendment and changes them in all the ways that folks have worried about on this panel, what are the sort of worst fears you have about that? And do you see any silver lining? Corynne.
Oh, the fears I have. Yeah. I mean, I have some pretty serious fears based on what we have seen after FOSTA was passed. I think that if, to the extent that we limit First Amendment and Section 230 protections for service providers, big and small, it's pretty much inevitably going to lead them to take the safest course, which is to take down as much content as possible that might lead to liability. And that's going to affect users around the country. And there is a context of this that I want to flag that I don't think we've talked about, which is that the other thing that has changed in the landscape in the past year is obviously the Dobbs decision. So what that means, we have a world in which people rely on the internet to get all kinds of information, including about their reproductive rights and about reproductive justice and access to medicine and so on. We could have a world in which it is illegal to provide that information or to host that information. This is not remotely far-fetched. And I think actually there's laws on the books that already could be interpreted this way. And there's going to be a lot of state difference about this, right? We're going to have different states with different laws, and service providers are going to have to figure out who, are national, usually in reach, or international in reach. They're going to have to figure out what are they going to comply with. So our sort of arcane little discussions over here about the internet, not that they're arcane, but you know what I mean, actually have much, much broader public policy implications that I don't think are being thought through or discussed. And I mean, I guess full employment for lawyers. So for the law students in the crowd, you have lots to do. But I'm really worried about that. I'm really worried about how courts are going to come out, and especially if it gets litigated in state courts, again, with competing constituencies and competing allegiances.
Oh, and just to tag, that's an institution, as we debated in the first panel, about where's the right agency to be handling it. Is the FCC, the FTC, is it a new agency? We haven't talked about state legislatures and courts. Interesting addition. Chris, your thoughts?
My biggest fear would be that we then have to test Congress to be better than Florida, and it's scary right now. No, it is frightening because, state legislators passing laws that they know are unconstitutional, and then and just saying the courts will fix it. We see way too much political grandstanding about content moderation in Congress these days. We've started to lose our well-established consensus that we had for generations around what the First Amendment actually protects, and it was worked out over time. Now we have folks saying that their free speech rights means that they don't have to be criticized, or that they have a right to be on every media platform that they choose to. That's never been the understanding of free speech. And so if we don't have a Congress that's better than Florida, then I worry that we're not going to have smart solutions to deal with what we're left with from the courts if that happens. And who gets hurt by that? I worry about marginalized voices, marginalized communities, the folks who benefited from having a low barrier to access this wonderful media that's called the internet, because they didn't have to have a license for a TV station or a radio station to be heard. we're talking about communities of color and other marginalized communities that benefited, have been able to organize and build communities online. If they lose that because of what Corynne talked about over-moderation, if we lose that, then, that folks out of power getting hurt, I think is the worst sort of outcome for this sort of court decision. And I had a friend say to me once recently that, oh, well, marginalized communities have always found a way to survive and communicate. And I'm like, yeah, but should we have to? I think that's ridiculous. We have a wonderful technology that if we only regulate it properly, can continue to benefit all of us to speak in ways we couldn't 2 decades ago. So.
Jen.
I think it is very concerning the impact that some of the proposed changes to Section 230, whether they come from the courts, the Congress, or state legislature, could have on all voices, on the voices that, as Chris pointed out, have traditionally struggled to find a place to speak, to find a place to connect with each other, who have been able to build wonderful communities through a shared connection. And for all of us who have benefited from being able to have access to a wide range of perspectives from around the world. When we're looking at what, particularly with the courts, I think there are two things. And I think when this conference is held next year, it'll be very interesting to see what the equivalent panel has to say. With regards to the Gonzalez case, I'm really interested and concerned about how algorithms could become something that are much more difficult for platforms to use. I highly commend, there's a brief that was filed in that case by a group of anonymous Reddit moderators. Had to get special permission from the court to file anonymously about how they're able to be volunteer moderators, in part because of the algorithmic tools they have to engage in content moderation. This is a very different type and style of content moderation than other platforms have, that without algorithms would be nearly impossible for them to do, particularly as volunteers. So I think it's very important that we very much pay attention to algorithms and the debates that are going on, or to the debate about algorithms, and particularly the potential regulation of algorithms. Secondly, when it comes to the states and to the question of the First Amendment, and we're looking at the Florida and Texas laws, if those are considered, I think it's I'm quick to point out that while it's been Florida and Texas so far, Florida and Texas probably have a very different view of what content moderation they would like to enforce on platforms than, say, California does, than, say, New York does. And inevitably, if you start to allow these kind of laws to occur at a state level, you're going to have a patchwork that, again, is going to really make it hard for users to speak, and is really going to make it hard for there to be a wide range of places for that speech to occur.
I think to Chris's point about marginalized communities, I think that's a really important point to remember, because frequently these laws are talked about as ways to protect marginalized communities. But almost in every situation, as soon as you give the government power to censor, they censor the speech that is designed to benefit marginalized communities. So I would say, if these changes happen, be ready very quickly for a law that bans access to all critical race theory internet websites, and that bans professors from accessing journal articles that reference critical race theory. I would say be ready for laws that ban all websites that talk about transgender individuals, that ban all research using the internet on transgender individuals. I mean, these are not the sky is falling scenarios. These are real scenarios of what could happen. In terms of will it happen, I don't know. You have definitely Alito and Thomas who've signaled their willingness to rethink everything. I mean, I was thinking my worst case scenario, Sullivan gets overturned, right? That's
For folks that are not familiar, can you say what that
New
means?
York Times versus Sullivan, the actual malice standard from defamation law, which has also been put on the blocks, is something that we need to rethink. But you also have some of the justices, if you read a case called Peckingham versus North Carolina, this was a North Carolina law that sought to ban anyone who was a registered sex offender for any reason whatsoever for life from any social media website. But it was written so broadly that it applied to the New York Times, the Washington Post, eBay, Facebook, a litany of different websites that were not social media sites, but that's the way the law was written, which goes back to my case about statutory law not being the answer. But the majority of the court writes a very flowery opinion that reminded me of Reno versus ACLU, the 1997 opinion by Justice Stevens. And it talks about the internet as being the new public sphere. Now, that's not just rhetoric that the court throws around. In legal terms, that means something. This doctrine basically says that there are certain areas that are long held bastions of freedom of expression, public parks, streets, places where people gather. And these are places where the highest First Amendment applies. And the court actually says that the internet is the new public sphere. And that's not just rhetoric when the Supreme Court throws it around, it means something legally. So you do have some of the justices who've really expressed this, that they still have hope, that they still believe in this marketplace of ideas, as messy it is, as crazy it is, as bad as it may be at some times, that it really is a place where debate can thrive and things can happen. So, you know, I haven't done my justice counting yet in any of these cases, which is something they tell you not to do in law school, but you do it if you ever practice law. But so those are my thoughts about where we'll be next year when this panel happens and you don't invite me back.
I fear we will have reason to. With that, happy to open it up to the audience for Q&A. And as always, the first question goes to a student. And you all have the misfortune of, I know who the students are here. So it's Sunday afternoon, but we'll still cold call if we have to. Why don't we go to Rich, who was actually up at the front of the room here at the beginning. So I know he's here. Rich.
Thank you. That was a great discussion. I want to come back to Gonzalez because I almost feel like its significance is almost downplayed in some ways. I mean, as of last night, it's the number of amicus briefs the court has received are approaching Obergefell levels. I mean, they're almost, excuse me, almost there. And I see the case fundamentally about personalization as the future of the internet. And I've begun to question the value of personalization and targeted content generally. And especially in the case of terrorist content, you know, being promoted, recommended. You can think about TikTok and the way that, you know, targeted content is part of the mental health issue there as well. Why not hold the companies responsible for amplification, for targeting? I mean, it's so impactful. I feel like there should be some legal liability at some point. I mean, at what point should they be liable for that activity?
So just to put a gloss on it, to what extent is Section 230 preventing accountability for the platforms in making recommendations that, to Senator Bennett's remarks this morning, arguably contribute to pretty serious social harms?
Yeah, I don't think you need to eliminate Section 230 protections to try to target some of those issues. Certainly, some of the data, the privacy and data protection proposals get at it a little bit, but not much. I would love to see, again, Senator Bennett, you want to have an expert digital regulatory agency, so do I. I would love for the agency to have the power to deal with wrestling with algorithmic oversight and what that should look like. And you can target some of that to the harms that you're concerned about without eliminating the thing that promotes free expression for individuals on the internet. That's where I start. There's probably others, but that's where I start.
So I'm not a Section 230 absolutist. I was getting some grief from some comments I was making about Section 230 before we were on a hot mic. But there is a smart way to amend it, and there is the ham-fisted way that we want to now because it's a political issue. There's a law professor for all you law students out there. Read everything she writes. Clayton Clonic out of St. John's University Law School. I always joke she was writing about Section 230 before Section 230 was sexy. And these were debates that people who teach in my area have been having for 10 years. And it's just when Donald Trump came into office and he said Section 230, then it became hot. So the two things that really upset me, my kids know this, Section 230 and critical race theory. Like, because nobody knows what it is, but everyone likes to throw it out there as something we need to be concerned about. And I say, okay, explain to me what it is before I take your word that we should be concerned about it. But she's done some really great writing about the smart ways that we might be able to edit it. And then Eric Goodman, is Eric I think he's on the EFF board maybe from Santa
Eric
Clara?
Goldman?
Yeah, Goldman, sorry, Goldman.
Nope.
Nope.
He's just awesome.
He is awesome from Santa Clara University. So 2 shout outs to Kate and Eric, read their work. It's fantastic.
Well, I will echo Derigan and remembering back before, everyone had an opinion on Section 230, back when it was this little kind of corner and you had to like explain to people what it was instead of them assuming that they knew what it was. And I also very much second both those recommendations of excellent people to read if you're looking for further reading on that topic. Content moderation is hard. Let me just start with that. This is a difficult task regardless of the size of the platform and regardless of how narrowly focused on a particular topic you may think a specific platform is. One of the difficulties in some of the calls for content moderation regulation, whether it's in the form of changing Section 230, we've seen this to some degree with FOSTA SESTA when it comes to conversations around sex in general and what we've seen platforms do with that, but is oftentimes these things that may seem easy to define are very difficult to define in practice. So if we say the debate that's going on about mental health content, for example, defining mental health content can be very difficult. What do we do about things that are there to help people that are trying to get mental health help and so on and so forth? It can become very easy to silence voices, as we've seen with SESTA FOSTA. When it comes, or to have the opposite approach in a world without Section 230 protection, where some of the good content moderation that many people want online to keep certain types of content that most users don't want to see gets eliminated, and you get a world that looks a lot like 4chan and certain other places on the internet where you can find those things. That's not what most of us want to see when we open our apps on a daily basis. When we're talking about policies intervening, the problem is then we're trying to dictate a one-size-fits-all approach, often from the government intervening in the speech of private actors. And that should be concerning, in my opinion, from what it means for the First Amendment. And I just always ask, when you think about the government being the one to define mental health content, hate speech, terrorist content, terrorist organizations, imagine the person you most politically disagree with in the world being the one with that power, and then ask yourself, are you still okay with giving them that power?
Let me give you something a little bit more concrete. Donald Trump is reelected president in 2024. How fast until Black Lives Matters is now a terrorist organization?
So all right, just keeping an eye on the clock. I think we've got time for a closing word from Corynne, and then we'll head to our break.
Yeah, so I think that just to sum up, the reason that some of us are Section 230 absolutists is that is because of what we've just been talking about. Is that it actually is kind of hard to tweak in a way that is actually going to target the thing you are trying to target. So, what violent content? Okay, you have to keep violent content off your service. That's one that people often like, and no amplifying violent content. Well, I think we've seen a lot of violent content that we absolutely want amplified, coming from, say, body cam, police body cameras, right? I mean, it's awful and it's terrible, but it's actually been really, really important that some kinds of violence have been made available to people. And it's hard to sort of write the algorithm that's going to sort of perfectly not that's going to differentiate. And then you say, well, you need to get a human involved. Well, now those are human people who are going to have to watch hours and hours and hours of awful content every day. That's not a great answer either. So these are, to me, the closing remark I would make is that too often, what is a very complicated and hard conversation is getting reduced, I think echoing now what Chris said earlier, getting reduced in legislatures to black and white, and it doesn't work. It's just the way that sort of content moderation happens in this moment can't be reduced to, on-off switches. And it's a real mistake if we try to treat it that way. We actually have to do policy in a way that makes sense. And I'll say last thing, the reason I know this in particular is because FOSTA, Barry, one of the reasons FOSTA is unconstitutional is also because it was rammed through and not thought through. It's a bad piece of legislation, even if you like what it was trying to accomplish, which was to limit sex trafficking and get platforms out of the business of facilitating sex trafficking in any way, especially child sex trafficking. But they wrote this bill way too fast in order to sort of score political points. And now we have something that's not going to accomplish what anybody wants, but caused a lot of collateral damage. So.
Well, I think we've solved it. The conference is over. No, just kidding. But we are, first join me in thanking our panel for the wonderful discussion.